All right. Looks like we have started. We got the announcement. My name is Gary Daddario. I am one of the partners here at Marcus Rico, Emmer and Brooks. And as probably most of you know, we at MEEB like to do these webinars to try to help people stay informed. With me today is another one of our partners, Jenny Barnett. And we are going to present on board action and the proper execution of documents. As is my habit to do, I just want to take a quick second at the outset to thank everybody who's with us today. We actually do have some good numbers this afternoon, but honestly, we appreciate everybody taking the time because our efforts wouldn't mean anything if you didn't agree to spend the time with us and get the information that we're trying to provide to you. So we're going to try to keep a bit of a pace today to make sure we get through all of the information, but we are going to allow for questions at the end of the presentation as well. And with that, I guess we can hit the next slide. So board action. Under this topic, what we're going to begin with is the appropriate standards. Next topic, or next slide. So the standard for board action is going to be in the governing documents of the association, and that's what needs to be followed. As we all know, from association to association, as similar as governing documents tend to be, they also have differences. And it's important to know for each association that you're dealing with what the standard is in their docs. Jenny, can we just go back one?
Oh, sorry.
Okay, that's all right. People watching this here this afternoon might be from different states. In Massachusetts, we would typically be looking in the what's called the Declaration of Trust. Most condominiums in Massachusetts are established as trusts for whatever reason. That's just a format that they chose. In New Hampshire, we would see standards for board action typically in a document referred to as the bylaws. And again, it's just sort of how things developed within the state. Most of the associations, the condominiums in New Hampshire, are either corporations or voluntary associations. All of that is just really sort of formality. At the end of the day, what matters is the language of the provisions in your docs. But in the neighboring states, they do tend to take different forms. Next slide, please. So board actions, this might be stating the obvious, but to frame the point that we're making, board actions impact the operations of the community. Their consequences are physical and financial, and all of that tends to affect the morale of the neighborhood as well. And so, when you have a neighborhood that's being well cared for, people can see where their money is being spent, the buildings are clean, the signs are legible, the lawn or the landscaping are well manicured. Those things tend to make people happy. Conversely, if people are driving into their own neighborhood and they're feeling like it doesn't look as nice as they want it to, or worse yet, if it doesn't look nice at all, that unfortunately has a big impact on morale. And that's when they start showing up very unhappy at the association meetings. Next slide, please. So given the importance of board actions, the last thing any board needs when they actually do, get into an issue, investigate it, analyze it, identify their options, make a decision, vote on a course of action, and start going down that course of action. The last thing they want is to be challenged or for the action that they're taking or trying to take to be deemed invalid. It could waste a lot of time, a lot of effort, and a lot of money, depending on the timing. And so boards do need to be careful about how they take the actions that they take and how they document it. They need to make sure they're on solid ground, not just with respect to the law in general, and not just with respect to what I'll call, substantive language in their documents, they also have to be following the proper process that is set forth in their documents. And, when you have disgruntled owners who don't want to see a particular project undertaken, don't want to see a condo fee raised, things of that nature. When you have folks in that position, they could be motivated to challenge the board. And so you don't want to make it easy. You want to make sure that you're following the documents with what you're doing. So there are various standards for board action. And by this, I mean for a vote that is before the board to actually pass, for the board to make a decision. One of those standards is unanimous. If any of you watching this have a set of condominium documents that says that your board needs to act unanimously, I don't know how you're operating so far, but you definitely want to make a note to amend that. Setting the board standard for action at unanimous is sort of like setting the stage for failure, because I've yet to meet a board who agrees on every issue across every member on that board. And one of the things that's nice about boards and the fact that they have multiple members, comprised of different people with different thoughts, is that you get different perspectives and you get different thoughts and ideas. That's the benefit of a group. And so unanimous just in practice doesn't really work. Most decisions of most boards, although they will pass by majority or even heavy majority, most of them don't pass unanimously. Another standard that we see often in the documents is a majority of board members at a meeting with a quorum. It's a common standard. It works. The quorum is usually a quorum of the board as opposed to of the community. If you're having a board meeting and you need board action to happen and it's a board vote and not a community vote, then you typically just need the quorum of the board. And at that point, a majority of those there will make or pass the decision or motion. And then finally, another standard that
I'm sorry to interrupt, but do you want to explain what a quorum is for people who don't necessarily know?
Oh, sure. Good point. Quorum is sort of your minimum attendance required to conduct business at a meeting. And the statute has sort of a default threshold, but almost every set of condominium documents will have a quorum provision that states what the quorum is at that association. And much like the votes that are required for, say, amending the documents, they vary, but not by much. They all tend to be in a range somewhere between, half or 51% and, 2/3 or so of the community.
And there's a different, oftentimes, right, a different standard for quorum requirements for board action versus unit owner action or
Yeah.
unit owner consent.
Yeah, the 51% to 2/3 is typically of the community. And then almost always for the board, the quorum is defined as a majority of the board. Here and there, sometimes they'll set the quorum differently, but that one's pretty consistent. If you're talking about just the board, then quorum gets met once you have a majority of them. And then that's actually the last standard that we see often in the docs for board action, just a flat out majority of the board members. I have a note on here, put it in red because it's important. It is often overlooked with unfortunate consequences, but unilateral action is never allowed. I've never seen a set of condominium documents that says that one board member can take action on behalf of the board. So board members need to be careful to not act alone, and that includes discussions with unit owners. It's unfortunate, but a lot of times unit owners, especially if they have an issue, especially if their issue is whether or not they're violating the rules or complying properly with provisions of the docs, unit owners will tend to remember discussion the way they had hoped that it would go. And that may not be an accurate representation of what the discussion was. And one board member can't help a unit owner because you can't make a decision on an issue And to the extent that an owner is misled, even if it was unintentional, if they are misled because they feel like, oh, I talked to Jenny, now I'm all set. Again, unfortunate consequences can come down the line.
And then just as a side, board members who might have an interest in the matter discussed, what should they do?
They should recuse themselves. If a board member has a personal interest, meaning that on a particular issue, they would be wearing both their board member hat and their unit owner hat. You only want to be wearing one at a time. So if the board is deciding an issue that actually has something to do with you and or your unit, then you as a board member should recuse at that point. I often get asked by board members, well, these are my neighbors. I want to be nice. I want to have good relationships with them. They approach me when I'm out there getting my mail. I can't be rude to people. I would tend to agree. You want to be a good neighbor and you don't want to be rude to people. But if an owner is trying to engage you in a one-on-one discussion, my recommendation is that you say to that unit owner, look, I understand your concern. I want it to be addressed and I want to help you. But I am only one person, and one person on the board can't take action or make a decision. So I'm going to ask you to bring this issue to the full board so that we can actually do something to help you. You can say it in a nice way, but you do want to make sure that people understand that you're not going to resolve the issue on a one-on-one basis.
You don't make promises or guarantees about how the rest of the board's going to act.
Right, right. Okay, so your standard, like I said earlier, for board action at your community is going to be found in your governing documents. By way of reminder, I have a note here. An amendment could change that standard. And so, like I said at the outset, if your docs happen to say that the board can only make unanimous decisions, I would change that immediately. Like I say, I already don't understand how you're operating under that standard, but I've seen it. And so if you have it, you should change it. Or if there are other things, about the standard that practically make it hard for the board to function, you could propose an amendment to the community to change your docs the way you would about another issue, and you could redefine your standard. For tips here, I have noted that you want to be sure to record board votes so that the validity of the vote can be proven. Some associations have documents that allow for board votes outside of meetings. If that is used, that provision, you want to comply strictly with that language. In other words, most often, if the governing documents give the board the ability to make a decision outside of a board meeting, that sentence goes on to say, provided that at the next meeting, all board members submit written assent to what was done, something along those lines. If you do that, if you make a decision outside of a meeting, you want to make sure that you strictly comply with whatever the rest of that provision is, because again, it can be very costly in a lot of ways, time, effort, and money, if the board makes a decision and a unit owner is able to successfully challenge it or invalidate it. Okay, proper execution of documents. Who should sign? Excuse me. Since the execution of a document is going to be a board action, in other words, you've decided to hire a property management company, you've decided to hire a landscaping company. That's a decision that you're making. You're entering into a relationship, you're spending the association's money. It is absolutely a board action when you're doing something like that. And so I strongly recommend that boards make sure that the execution of the document is consistent with their standard for board action. In other words, ideally, all of the board members would sign a contract. If they do, then there's no question that that was a board action. There's no question it was a valid board action. There's no question that there was some misunderstanding or miscommunication or anything of that sort. At a minimum, let's say your docs require a majority of the board for board action, well, then at a minimum, you would want at least a majority of the board to have signed that contract. Reason being that, like I mentioned, unilateral action is not allowed. And we often see contracts that have been signed by one member of a board. A lot of times it's a board president. And what's unfortunate is at that point, if you have a document with only one signature, looking at just the document allows for the question to remain as to whether or not this really was a board action. You don't have the right number of signatures, and if someone's looking at one name on the page, then they can say, well, how do I know that the rest of the board was behind this, or even that a majority of the board was behind this? I'm looking at one signature. Can we just go back one for just a second, Jane?
Yep.
Um, oh, okay. So there's that was part of what I said. So yeah, you want to try to get all board members to sign. Then there's no question, but you at least want to meet your standard. And then the names of the board members should be signed and printed, and the date should be noted.
Would you suggest that if there is not an updated trustee certificate or identifying the composition of the board, that that be recorded simultaneously as well?
Yes, and that's something that's different in the different states because in Massachusetts most condominiums are trusts. You have trustees. In New Hampshire, with the voluntary associations or the corporations, you typically have a board of directors. And the board of directors can be filed sort of with the state corporations division, whereas the trustees of a trust file a simple certificate at the registry of deeds. But yes, that's a bit of housekeeping that can come back to haunt boards because if someone is doing their due diligence on the other side of a transaction, whatever it may be, whether you're hiring a vendor, signing a contract for something, you could be settling a legal dispute, you could be doing something that's very positive and that's going to have a good impact on the community, but people can question that action if you didn't have authority to take it. And we see it a lot with closings. Well, I shouldn't say a lot, but the most common scenario where we see it is in a closing scenario where the closing attorney happens to be doing a very thorough job. And so sometimes they will say to us, oh, we got what in Massachusetts they call a 6D certificate. In New Hampshire, they tend to call it a resale certificate. Some attorneys will say, well, we got one. It's signed by several board members, but I don't see these people being the board members of record. And so, to Jenny's point, if you're not keeping up with either the registry of deeds or the corporations division, whoever's keeping the records of your association in your state, if you're not keeping that up to date, you can run into issues. Comes up a lot, actually, with bank loans. It's very common nowadays. The average age of a condominium in our geographic area is putting them at a place where major projects need to be done if they haven't been done already. 30-year roofs, 30-year siding, the parking lot, pavement, all of these major components. In the average condominium in New England, they've had enough time to age out. And a lot of associations, if they don't have the money on hand, are now turning to banks who have products designed for associations to borrow money. The bank is going to be careful when they're lending you money. That's another scenario where if you have a bunch of people trying to sign something as the board, but your records are not up to date, a loan is another situation where I'll hear from the bank who says, I'm looking at signatures that don't match what's on record as the people that are the board of this condo. That situation can be unfortunate because that can cost you time, for you to remedy that and then revisit the loan paperwork. And sometimes boards are really trying to get that done quickly.
And that brings us to when How many times have you had a situation in which a board will say, just have the property manager sign, or why can't they just sign for the rest of the board?
That happens a lot. In fact, a lot of times boards say, oh, we always just have the president sign everything, or we always just have the property manager sign everything. And, some property managers want to be helpful. And if the board wants them to do that, they want to do it. Other property managers are concerned, as they should be, because there's a certain amount of liability that's going to attach whenever your name is on a document. And I have certainly had those cases where the relationship breaks down between the association and the vendor. They get into a dispute. The dispute can't be resolved. Now people are making claims against each other in court. And then lo and behold, one side or another might actually attack the validity of the contract itself by saying wasn't signed by a proper party. It wasn't signed by someone who had authority to sign it. Therefore, whole contract is out the window, so to speak, to use a professional attorney term. Um, so yeah, that one comes up a lot. And is that are we at that slide, Jenny? I'm not sure if
Yeah, so in terms of property managers or being agents of the boards, that's, you have that one. I mean, I think it's still you, right? Sorry.
okay. Yeah, where are we at?
So,
I don't see the numbers. Sorry.
um, so this is 10, I believe it's 10. Sorry.
Okay.
So
Um,
this is the one, going to your point, being how to sign if a property manager is signing, what I typically do is if I'm drafting the document and putting the signature line, I include language that identifies the property manager as, in their signing in their duly authorized capacity as managing agent or property manager, and not expressly stating it's not individually. I'm dealing with a case now where a vendor performed work solely within the confines of the unit, and the property manager signed. It was an emergency flood or water infiltration situation, and the contractor actually sued the property manager, not the unit owner, because the unit owner has since sold and they have no other, party to go after.
yep. So part of the language on this slide addresses that a bit in that, if a property manager is going to sign, maybe they agree. In other words, maybe a board would like the property manager to be signing contracts. Maybe the property manager is willing to do that. If they both agree and that's how, the situation is going to be handled, then I think it's just important to, state it in the management contract, what authority they have, including the authority to sign, contracts. At least you can describe the type of contract or set a dollar amount or something, to sort of define that. And then you have to be careful, and this is what you were just saying about avoiding vendor confusion. If the property manager signs it, they should sign it as the property manager, so that the vendor does not think that they have a contract with the property manager as opposed to the association. We can hop on to the next one. So some state specifics here. This again gets to documents that are being signed pretty regularly by boards. In New Hampshire, the Condominium Act requires liens to be signed by the president or other designated officer of the association. That's a big difference, by the way, between New Hampshire and Massachusetts. In Massachusetts, condominiums have an automatic statutory lien as of the date the assessment was due. So you set a due date, a unit owner doesn't pay it, and under Massachusetts law, the next day you automatically have a lien. You didn't even have to do anything. In New Hampshire, a lien document needs to be created. It's usually just a page, but it needs to be created and it needs to be recorded at the Registry of Deeds. As I said, the act requires it to be signed by the president or other designated officer. So in this case, and this is one that we get a lot of questions about as well, in this case, it's not going to work to have the property manager do it. I understand that that's a lot more convenient. Practically speaking, that would be easier and faster. The risk is that if a unit owner is desperately trying to defend themselves from this debt that perhaps they can't pay, to the extent that the wrong person signs a lien, then the lien can be challenged and a court could decide that that lien is invalid. And in fact, the Supreme Court of New Hampshire has made that decision in some cases that have been litigated for one reason or another. Basically, their overall attitude towards the liens is they need to comply with the statute strictly, and if they don't, they will be stricken.
And does that discharge the underlying debt?
Um, it it depends, I think, on exactly what the court states in the order. It certainly dispenses with the lien. If they invalidate the lien, now there's no lien against the property. And so even if you can still chase the owner for that money, you've lost a lot of your leverage. Mm-hmm. Sticking with New Hampshire, second point on that slide for you. Yep. It allows amendments to be signed by the president and the treasurer of an association with a certification of the community vote by the clerk or secretary. That can actually be helpful because the alternative might have been, in some associations state this in their document, that an amendment needs to be signed by all of the unit owners. That gets to be a bit unwieldy, and it gets to be a problem for recording and the expense of recording because you're going to have pages upon pages just for signatures. And so it's a little bit of flexibility that gets created there when they say that the president and the treasurer can sign with a certification of the vote by the secretary. And that certification is usually just one or two lines. It's basically just the clerk or the secretary of the association saying that this amendment did in fact pass the requisite vote of the community. Even though it's being signed by, 3 people on the board, there was a community vote and it did pass the community vote in the appropriate standard. And that's all the certification is. But that's how those signatures need to be on a New Hampshire amendment. Now, we have some Massachusetts specifics. As I mentioned before, no paper lien is required because in Mass there's an automatic statutory lien. When it comes to amendments in Massachusetts, the statute leaves that to be addressed within the governing documents in terms of who signs them. And so association by association, if you're working on an amendment, you're going to want to make sure that you've read the relevant provision of the document and identify there who is going to be required to sign that amendment in order for it to be valid. Who should sign it? Is this where we transition, or is this?
Nope, you still have it.
Okay.
Next two.
So who should sign? Anybody who knows me is laughing. I would talk until tomorrow and be perfectly satisfied to do that. So I'm trying to make sure that I don't run into Jenny's portion here. Who should sign? The board members that are sitting in office at the time that the document is being completed are the members who should sign. In other words, we see this a lot with big projects. One board starts in on the project, they get proposals from 3 vendors, then they start negotiating a contract. Those negotiations might go on for some period of time. And, we're close but no cigar. And then lo and behold, the community has an annual meeting and an election, and the composition of the board changes, and now you have new board members. A lot of times the new board members are a little bit shy about signing a contract. In other words, they come into this position and they're a little bit nervous about putting their name on a document that they don't have the history that goes with that document. They know a lot of time was spent and a lot of work and effort, but they are not familiar and they don't like the idea that their name's going to be on something that's not familiar. Similarly, the board members that were involved, that spent all that time and effort doing the negotiations and that contract and this project was their baby, so to speak. Those board members actually want to sign it because they believe that's sort of the culmination of their efforts and that's how they finish off the project. The problem, unfortunately, is that from a legal perspective, the only board members who have authority to sign on behalf of an association are the board members in office on any given day. And so it's really a question of when is the contract being signed, like literally what day, and literally what are the members of the board on this day. And that's who has to sign. Sometimes, you can ease any practical issues by having a transition meeting between the old board and the new board and letting people fill each other in and things of that nature. But at the end of the day, it's got to be current board members whose signatures are on a document as of the date it was signed. Otherwise, the door is open for a challenge. And what we've been talking about so far in this presentation is making sure that when the board takes action, it's a safe action that's going to be defensible, that's going to be hopefully relatively safe from challenge and safe from being invalidated. And, that's how you have to handle it when it comes to who has authority to sign.
So now, once you have the authority, then it's a matter of documenting. Often this requires the board members to sign before what's called the notary public. And oftentimes this is where a notary is required if you are signing for a loan, if you're signing for a closing of the sale or transfer of real estate, or any official type of document filed with any type of government or state authority, such as even the registries of deeds in New Hampshire, in Massachusetts, and pretty much throughout the country. These will have a block at the bottom, and what's called what's often referred to as a notary block. This needs to be so notaries can be found either by going to a bank, town hall, city hall. If you don't necessarily have to hire a lawyer to have a document notarized. If it's a contract, you might want to get a lawyer involved before signing and prior to the negotiation. But for purposes of signing, if a notary is required, it can be done without a significant cost. Notaries are specifically licensed within each state. They are empowered and vested with authority to witness the document signing, verify the identities of persons. So if you're asked to go to a closing or a bank loan closing, real estate closing, any situation in which a notary is going to be present, be prepared to show your license or other form of identification. If there is in the notary block I was just referring to, the notary has to identify specifically what type of identification they relied on to verify your identity. One option is personally known to them, but it's rare in that is I don't often see that uh situation. Is more often that you're identified through some sort of governmental ID. So just make sure if you're called upon to sign before a notary that you're prepared with the documentation. Otherwise, you'll have to come back or reschedule the closing. They also will ask you if you're signing of your own free will. This is important so that to prevent coercion. And the purpose of a notary is really that last safeguard to ensure that the document is legitimate, that is not being intended for fraud, and that the person is who they say they are. when signing, so that this is intended really to prevent people from forging signatures or improper transfers or taking out loans without any sort of authority. And again, they have to formally attest in Massachusetts. There's a number of additional requirements that have passed in recent years requiring notaries to keep a log of every transaction in which they're asked to notarize. And so it's not a easy task, and it's just a formality. They truly serve a function, uh, and when a notary is required. The notary is the notary that you need is where you're signing, the locality where you're signing, not where necessarily the property is located, or where the document is going to be filed for registration or recorded. So if you're in New Hampshire, but it's a Massachusetts document, you're going to find a New Hampshire notary. Similarly, if you're in Massachusetts, but it's a New Hampshire document, you're going to need a Massachusetts notary. You don't have to go to any specific location in Massachusetts. You just need to wherever you are, you can go on actually, I know in Mass, and would expect that it was similar in New Hampshire. You go to the state website and there's a list of notaries. If you just type in find a notary public.
I think you see them a lot at certain types of businesses and offices, like banks almost always have a notary. Real estate offices always have notaries around. And those are things that are usually one or the other is fairly close to where people are at any given time.
And members of the board can also apply to be a notary public. It's not too onerous of a task. You have to fill out the paperwork. It requires you to have two attestations, at least in Massachusetts, and get sworn in before a local court to accept the duties of the responsibility of that role. And then you're required to maintain your license. It renews periodically, but you have to remain in good standing. If a notary is not in good standing, they're not authorized to notarize the documents. And now when I say good standing, I mean their certification has not expired or been revoked.
I think the hardest thing with the notary is the free will part. The board member has to confirm that they're signing of their own free will, because in my experience, most people who are on the board at all are there because they're forced to be on the board.
And yeah, so that's the situation, I'm
I've
sure.
had joke for a moment.
We have situations, where people ask questions at closings and say, well, I don't really necessarily agree with this. So that a notary is often called upon to deal with those types of situations, which may be a difficult scenario, and may delay a closing if the person answering the questions is simply a bank employee and not an attorney, because uh, someone unrelated or a third party may not have any knowledge or expertise to answer the specific questions about the implications of signing. So again, it's important that you fully understand the documents you're signing, that you're doing so of your own free act and will. And that goes whether you're signing in the capacity as a board member, property manager, or as an individual. Let me just again, so if you're signing a document, you're going to be presumed to have understood the terms, agreed to the terms, and it's going to be difficult to invalidate based on a mistake or a misinterpretation or a misunderstanding. Mutual mistake may be grounds for unwinding a contractual provision or a contract. But if you don't understand a provision and you sign, and ultimately it could come back, hey, to use another really, strong legal term, bite you, because so don't sign anything you don't fully understand. It's better to ask questions, even if it results in a delay of a couple days. The long-term consequences are much, much worse if you sign a document you don't fully understand or don't agree with. If have been doing litigation for 20 years, so I look at things in a different light than other people. But always look at, if somebody says, "Oh, that will never happen," I can tell you 10 different times it has. So don't hope for the best, expect the worst. What could possibly go wrong? And that way you could try to account for every scenarios to protect yourself, to protect the board, to protect the association. Like I said, even if it makes you unpopular, it's better in the long run.
That's an excellent point. Actually, as a litigator, Jenny's day, all day, every day, is dealing with the things that all of us said were never going to happen. So bear that in mind. Sometimes as association legal counsel, we give advice that isn't fun, or we tell people that they need to do things in a certain way that isn't easy to do. But we do see it. The thing that you think is never going to happen, that someone is going to challenge it, that the court is going to undo your contract or your project. Unfortunately, we do see it. Jenny, in the first instance, she's one of the folks that goes to court to fight those battles.
I often feel like Toby in The Office, like wah, wah. Um, so don't leave blanks. Don't leave. So just the TBD is gives me such anxiety when I see it, because it's like, just, we'll deal with it later or we'll address it later on. Don't accept that. Make sure the dates are filled in. Make sure that any provisions regarding timing or monies or um, daily fines, penalties, anything that uh, may be controversial and you may be unpleasant to discuss, don't leave it to chance. Even if you think it's something as simple as the at the outset where it states the date of this agreement, that may still have consequences if you're talking about deadlines and from the date of the agreement. So if that date's blank, then it could lead to dispute and controversy down the line if the project goes beyond what was originally anticipated. And this can also be, don't leave, if it calls for a specific provisions on our, for example, a type of snow removal contract. If it states that it leaves blanks to specifics as to how snow is going to be removed, where snow is going to be uh, placed. Is it going to be removed off site, for example, or where the location? If we have if a winter like we had this past year, I've gotten calls about where to put excess snow and if it's not going to be removed from site. Things as simple that you wouldn't necessarily think about, don't leave TBD.
And the legibility, I think, is getting more important. We are constantly recording things on behalf of clients, which is absolutely fine. But at least for those on the call, this gives me an opportunity to tell a bunch of people at the same time. The folks at the registry are viewing their role differently lately. I'm starting to imagine them thinking of themselves as goalies. They're blocking the net of the registry, and anything that they can keep out of there, it seems like that's the new method of operation. And I have seen real life example, another one of these things that people think won't happen. When people are signing their signatures, people often like to have, some sort of fun signature or something artistic, whatever. That's great for the signature. We've had some documents come back where even when people are printing their name, if they haven't printed it in a way that the employee at the registry can actually read that name, they're kicking that back to us and saying, we can't read the name, we're not taking it.
And that's just the recorded side. When you get to the registered land side, it gets even more complicated. If you leave out your initial, If your initial is John D. Smith on your deed, you better sign that document, John D. Smith. If you hold the property in a nominee trust, you need to sign as trustee, otherwise it may get rejected. And this can carry consequences because you could result in a stale document, meaning the registry with at least the registered side of land in Massachusetts, sorry, has a recorded side and a land court registry. If it's a registered land, everything has to be filed for registration within a year at the outside of signing. The documents are governing, so documents may call for a lesser time period, but the outside window is a year. If the documents are not filed with the registry within that year deadline, you have to start the process all over again to get the signatures. And people may move, especially with the resort types of communities, and it just can become a big headache. So make sure the signatures are legible, make sure that people are signing in the appropriate capacities, and you know, taking those extra steps in those few minutes. It may be annoying, but it will save you hours, if not days, months later on in the event of potential controversy, or if you have to go back because something wasn't done properly. So that brings us to contracts versus promises. So contracts typically should be signed, and to form a contract, I'll give you a quick, law school 101. You need to have an offer. So Gary, I offer you to buy you a sandwich. And so if Gary says, great, that would be a promise. Great. He hopes I take him up on it. But if he's
Great to that.
but if Gary says back, I'll buy a I'll pay for this. You get me this sandwich and I will cover a closing, or I will buy you a sandwich next time. Then that becomes an agreement. It's an offer and acceptance, and he's giving me something back. And so the consideration would be the promise of performance. And it would have, and the consideration would be him buying me lunch. I'm buying him lunch. The intention, we would have to, if parties don't agree necessarily to be bound to that agreement, that may not form a contract. For instance, if you say, hey, I'll get you next time, it's not as intentional as a specific offer, except in a consideration coming back. The capacity, individuals must have the capacity to act. So if a board member is no longer on the board and signs a contract, this is going back to Gary's old point, then they don't have the capacity or authority to sign. Also, people under 18 can't sign contracts. If they sign a contract, it can be ratified after they turn 18, but otherwise it might be a way to invalidate a contract. For those of us of a certain age, you might remember those penny CD clubs. That seemed like a great idea. And so I think it was, you get 10 CDs. Do you remember this, Gary?
Yes.
And so if you saw in, so you get 10 CDs, but then every month they kept sending them. So the way most of us got out of that endless cycle was, responding back, hey, we're like 16, 17 years old. And it finally stopped. Otherwise, I think we'd still be getting, cranberry CDs. And so also the contract you're entering into has to be legal. So if the agreement's to do something illegal, to perform some sort of illegal task, or to do something that's not authorized under the locality in which you are, then that would not be enforceable. So you can't go to court to enforce an illegal agreement. A promise, typically a promise is not enforceable unless somebody relies on it. So if somebody acts or refrains from taking action because of a promise, it's called that's detrimental reliance. That may form a basis to pursue relief if the party who reasonably acted in reliance on that promise suffered damages. So if somebody stated that they were going to, if you buy this property, I won't build I'll make sure that you'll have easement rights to the adjacent properties. If then they turn around and grant easements or that obstruct or they don't grant easement rights, and that was, that formed the basis for your agreement to buy the property in the first place, that might form a basis to go forward on a claim of detrimental reliance. And your recovery, if you prevailed, would be the amount of damages. So where would you be had you not relied?
Here's one that the folks on this call will probably find near and dear, by way of example. Um, let's say that you're an association who is going through the process of getting your snowplow guy under contract for the next season. You may walk the property, you may show the contractor things, the contractor may tell you how they plan to go about doing the job. And if you're careful, you may say to the contractor, by the way, any damage that you cause, you can stake the property and mark it, what have you. But if you blow through your markers and you destroy our sidewalks or our berms or our mailboxes or anything else, you're going to pay for that, right? And most contractors will say, oh, absolutely. Anything we damage is going to be fixed. That's on us. Um, that's a promise. That's all well and good, but you're going to need to make sure that that's actually in the contract, because unless the contract says that they are going to fix at their expense anything that they damage, chances are you could be chasing them for a long time if you don't
And
have that language.
and also that discussion is usually before the signing of an agreement. And so these agreements often have a clause that states this agreement supersedes all prior discussions and forms the entire basis of the contract. There's no, sometimes there's even a clause that says there's no representations that have been made except, and that's where you want to make sure you put that representation. Don't hope that he seems like a really nice guy or they seem like a really nice woman. That's great, but don't leave things to chance. You're entering into a relationship. You want to think about what could possibly happen. Even if you don't want, even if you try to avoid conflict, if that's just not in your personality, it's better to have those conversations than to end up in protracted litigation. So an express contract, and I'm going I hate to bore you, express contract. So it's very clear the terms, the material terms. I'll give you, if you do, it will offer you A to do B or to give me B, and uh, time for performance, easy, should be straightforward. An implied contract, this is more direct word, it's more actions than words. So if somebody goes out and this is the classic example is painting the fence. So you see somebody goes out, starts painting the fence on your property. You walk by, you say, "Hey, great job." And then at the end, once they finish, they come to you and say, "Okay, that's going to be $50." You can't then say, "Wait, what?" They had an expectation that they would be paid. There was an implied agreement that they were doing this for compensation, or sometimes what it's called is it's a quasi merit. They should be paid for the value of their work.
I,
An implied contract can also happen because of just the parties' relationship over time. Sometimes this may happen because, especially with landscaping contracts, a landscaper may come do the spring and fall cleanup every year and they signed an agreement maybe a decade ago, but they've come back every year since, without having another contract executed year after year after year. And so you can't, if that situation, if the parties performed in accordance with past practice and without any sort of uh, change in circumstances, that would likely hold up as an implied contract. Um, a bilateral contract is usually, I will refrain from doing something. If you do, this might be a release agreement, a mutual release. So I release you, you release me. We're not going to sue each other and we're going to go our separate ways. Uh, a unilateral contract, this would be, oftentimes the example is a life insurance policy. So the insured pays premiums when they pass away. That's when the insurance company's obligations are triggered to pay out on that policy. Their obligations to pay would not become triggered until that specific event. Also, another example might be a sweepstakes. So everybody, if you enter into a contest, then the you don't have a right um, to recruit or to prevail or to any type of award unless you're selected by the company running the agreement. And so it's a unilateral contract is less has less powers for the party who's performing right away. The other party doesn't have a right obligation to perform unless that first party performs first.
I have a quick cautionary tale on implied contracts. And again, I think people on this presentation are going to recognize this sort of scenario. But an association had a unit owner that was severely delinquent, and they were making payments to try to catch up, but the payments weren't much, and it was really going to sort of take them more or less forever to get their account current. And so the association authorized me to continue the collection process, which involved going to court with them as a next step. And when we went to court, they argued that they've been making the payments they've been making. The association has been accepting them. They should be allowed to continue to do that. And as much as I think that the judge was just plain wrong to do this in the context of a condominium collecting their assessments, the judge did find that there was an implied contract between the parties because payment was being made, payment was being accepted, that had gone on for a long enough period of time that the judge said to the association, you're not going to disrupt this now. It's gone on long enough that's how this is going to finish. So all associations have delinquencies. You all have those people that are kind of trying and making payments. As the association, just be mindful of that situation because if you don't want it to go on forever, you may need to do something about it sooner than later.
And a repayment agreement should be in writing. If you are going to entertain it, it should be in writing. It should have it should specifically state that if there's a breach or default, that the board's going to go forward and pursue it in action. A lot of times the board, these are your friends, your neighbors, people you've grown to respect and trust. You don't want to put them in a position where you feel that you need to formalize a repayment agreement. But I've had the same scenario that Gary has, where there's a party, the board's entered into an agreement in good faith, and the other party doesn't perform. But just because of the actions, they are stuck. What the expression is no good deed, right? So that's why you need that agreement. Have the attorney be the bad guy and just say this, our attorney insists that we document this. At least that way, you have something in place, and it's in everybody's interest to memorialize the terms of the agreement. This also goes with vendor contracts. If you're going to hire a landscaper or vendor or anyone who's going to provide goods or services to the association, the agreement should be in writing. Include a detailed scope of work. What's the standard for performance? If it's going to be, for example, a repaving, uh, what is the standard? What are the minimum bituminous requirements for thickness and depth? And do you need to remove and replace any part of the existing pavement? So I would have an objective standard based on an accepted authority. And you want to include price and payment terms. Don't leave these to chance. Don't, if it's going to be time and materials, specify the measure of and that you're going to be using. For example, if it's going to be per hour or per if it's a salt for a snow removal, specify how much it's going to be so that you're not shocked at the end. If it's going to be a per inch contract, what are the per inch, what are the measurements that you're going to use? So is it 0 to 3? Is it 1 to 5? And how much is it if you fall into those categories? What's the standard? How are you measuring the snow? And I'm only saying snow removal because I see those a lot, especially now that the weather's getting nice. The final bill comes in from this winter, and people are often shocked because of the amounts. So that's a great example of why you don't want to leave things to chance. And everybody needs, so if it's 0 to 3, you want to make sure you're specifying that it's 0 to 3 in your location, not 0 to 3 at Logan Airport if you're in Springfield. Uh, the duration of renewal, what are the terms? What's the length of the contract? Is it going to be automatic renewal? What are the terms? How do we, prevent it from the automatic renewal? What steps do we need to do? Insurance and indemnification. You want to make sure that if you're having a contractor on site, that they are licensed and insured. Double check. You can do this going to the state's websites and looking up the contractor's registration on the Secretary of the Commonwealth's website. There's a corporations page that you can look up the status of the corporation. You want to make sure that they're in good standing and they're not their corporate status hasn't expired and that they're not just doing business as an individual, because that has different ramifications in terms of just the scope of potential recovery if they were to breach or default their agreement. And a termination clause. How do you terminate the agreement? If everything goes poorly, is one side going to be unfairly benefited or harmed? So if a contract states, and oftentimes this is in the bigger types of contracts, it will say that a contract, if a owner terminates the agreement, that they have to pay the contractor the value of the work performed plus what their profit would have been, and that for work, this is for work that's not even that they haven't even done. If you probably, if the owner oftentimes is not terminating just for, on a whim, they're terminating for cause. So that's a hard pill to swallow if you have to pay their profit and pay extra just to get out of the agreement. And that brings us to the last boilerplate provisions.
And just one quick thing, and it's because I see it come up a lot. Just make sure as an association, either if you're the board or the property manager, whoever's running point on the contract, just make sure that there is even a termination provision. I have lost track of how many times I get contacted by clients who say, we want to fire whoever it is, and we can't figure out how to do that. Here's the contract. And they give me the contract and I look at it and I say, well, the reason why you can't figure out how to do it is there's no termination provision in here.
And oftentimes it's just a proposal. You accept the proposal and there's no formality followed after that, and it's just the proposal is signed and it's just invoicing. And so in that situation, there is no terminate express termination clause, and that's would be something that we would probably recommend if the agreement was brought to us beforehand. And that sort of brings us to that point is that if, yes, it is expensive to hire an attorney, and I know people are reluctant and think that they can do the contract negotiations through AI, but there's so many nuances to these contracts that only could come, and our recommendations and changes, they can't be replicated through AI. It only comes through real world experience and in our own day-to-day interactions with, our knowledge of vendors and contractors. Oftentimes, an agreement involves a contractor or a vendor who we've worked with or we know of. So that it is important to at least have an attorney review the contract before signing, especially the renewable contracts such as landscaping, snowplow removal, and yeah, many times a contractor will just present boards with a form of agreement on there for, and say here to sign. And it will contain what's called boilerplate provisions. These are pre-printed clauses that are benefiting the contractor. When a boilerplate contract provisions are not intended to benefit the other party. They're one-sided oftentimes, and they have very limited they allow for very limited rights for the other party beyond the contractor, and in the event of if things go wrong. So, and they often call for attorney's fees and costs in the event of any type of late payments. They may call for arbitration instead of litigation. And but it's not all lost. You don't have to sign a boilerplate contract. Just because it's boilerplate doesn't mean it's non-negotiable oftentimes. I'm that person who will, strike out, and even for a short-term rental agreement, I will strike out provisions and because that are objectionable, but you don't have to sign. So just because it's put before you, just that it doesn't mean that there's not an opportunity for further negotiation or for you to seek out the advice of counsel to add or eliminate certain terms that are objectionable or will put the association in an unfair position if things were to go sideways. So recommended practices. Gary, do you want to?
Sure. So confirm the board's authority under the governing documents. Understand what their standards going to be, for how they act and what consent they need. Memorialize all agreements in writing. Don't rely on verbal agreements alone, or use the initial contract proposal. A lot of times those proposals are nothing more than the vendor saying, here's what I'll do and here's a price for it. But that information alone does not make for a good contract. You want to properly screen all vendors and contractors, make sure that they have the right qualifications and the capacity to do the job that you're looking for them to do. But also on an objective but specific level, make sure that they have the right license to do the type of work, make sure that they have the right insurance.
I just want to jump. I'm sorry. I just want to jump in. As far as when you're speaking with the contractor initially, they should also be familiar with the association's rules and regulations. If you have any construction guidelines or rules in place about working hours, and if you have use of elevators, that nature, even though the association and not a unit owner is contracting for the work, the board should still insist upon their contractors and vendors following the same rules and guidelines as any other resident. And a board and the contractors should have a copy of those at the outset.
Yep. Another one that comes up is use of electricity and water. Different jobs need different things, and that all needs to be sorted out. Sometimes parking is an issue, depending on how many people are going to be coming to your property to do the work. All of these things need to be hammered out in advance. You might have ongoing contracts, but it's a good idea to review them at least annually, so that if an adjustment needs to be made, that adjustment can be made. And then lastly, consult with association legal counsel when reviewing, modifying, or terminating your agreements. This saying really applies here. An ounce of prevention is worth a pound of cure. I get it. People don't like to call attorneys unless they have to. One of the primary reasons for that is that they don't want to spend money and they know whatever the attorney does is going to generate a bill. But I can say with all honesty that by and large, an association will spend less involving a condominium attorney at the outset of a project or a contract or whatever the issue is than by bringing them in at the end when there's a problem. Because those are harder situations to handle, and it actually takes more time and effort to do so. And then everybody also is in the middle of a bad experience. So it usually pays off financially, and in other ways as well, to get a little bit of legal work done on the front end of things to avoid problems, as opposed to just trying to deal with them when they come up.
And we even hire our attorneys to negotiate as well. It's not these agreements are not something that should be entered into lightly or without being fully aware of all the potential facts, circumstances, and aware and informed of all the possible sideways ways that things could go awry, and to make an informed decision on how to proceed. Taking some of these questions, if we want to implement some of these suggestions you're making, what's the process for updating the governing documents? Who needs to approve these changes?
So the process is typically set out in the governing documents. They will have an amendment section of its own. So usually that's a heading. You could spot it very clearly as you're flipping through amendments. It's always its own thing. That will tell you what your process is going to be. It will tell you what your voting standard is going to be. Usually amendments need to be approved by somewhere between 2/3 and 75% of the community. Although this kind of goes without saying, sometimes the docs will also specify that any amendment needs to have the support of at least a majority of the board. And then finally, something you need to be careful of. A lot of documents identify certain types of amendments that trigger the need to also get the consent of the first mortgage holders. That's tough because that's usually the most time-consuming and expensive part of the process, because the only way you know who's holding a mortgage on a unit on any given day is to check the title of that unit. And then you have to prepare a notice for that mortgage holder and send it out. The law specifies by certified mail, which is now up to about $10 per envelope. So a lot of times, that's the toughest part. Not every amendment requires mortgage holder approval, but the docs will usually identify a list of things that do. And usually they're big things like we're going to terminate the condominium, or we're going to sell some of our common areas, or we're going to change the percentages of the units. It's usually fairly big things. Sometimes it can be surprising. Sometimes on that list are amendments involving leasing or rental of units. Usually associations think of that as an association issue, but sometimes that's one that will require mortgage holder approval as well.
Next, what if the board wants management to sign on their behalf after a documented vote to approve the contract?
You could speak to this from a litigation standpoint, from a general practice standpoint. I think as long as that's documented, that's okay. In other words, the board can give the board can give the property manager the authority to sign the contract. They should document it either in the management contract or by voting as a board to authorize the manager to sign the contract. Uh,
Many times there will be a delegation of authority, a certificate of delegation of authority that's recorded as well, that specifically identifies what authority a property manager or managing agent might have, whether it's to execute 6D certificates, to sign agreements. If it, many times the agreement, property management contract will specify the types of contracts up to a dollar limit that the property manager may sign. So it's just there's a lot of different variables I think that have to be considered.
yep.
Let's
That's
see.
kind of a comment. It says at a board meeting, the board can vote to authorize the chair to enter into a contract. Um, I think that is true. I think that when that happens, we're talking about a specific contract. In other words, usually there is a contract on the table, like it literally physically exists. And then the board might say, all right, we're going to all vote to authorize Jenny as the president of the board to sign the contract on our behalf. And that will work. Just bear in mind that if there's ever an issue about the validity of the contract or whether or not it was appropriately executed, it might require then a second step. In other words, you're going to look at the contract first and see Jenny's signature as the president. And then you might need to go a step further to prove to everybody that the contract was valid. And then you might show them the meeting minutes where the board took that vote and everybody said, we're going to have Jenny sign it. So I think you can do it. It just might, you just want to do that vote and keep a record of that vote in case you ever need it.
That can be done in the meeting minutes too, especially if the association's required either under the documents or in New Hampshire to um, to keep meeting minutes. So the meeting minutes should not include much more than who is present and if their votes taken and whether or not a quorum was reached. That can all be memorialized in those meeting minutes as well. Um, Preferably signed at the next meeting to ratify the accuracy. But I know we're getting late in time, so let's see. Do you still need to go through all these steps to sign, for example, a landscaping contract?
I would say yes. Any contract that involves, work being done at the association and spending of the association's money, I would treat them all the same. And I would try to have a consistent process. That makes it less likely that there will be errors if you get used to how you handle contracts and you always do it the same way.
Yeah, I mean, we're just talking about the recommended practices. We understand that this might not always be possible, and so I don't want people panicking at the end of this either. But we can only recommend steps for going forward. Is there an issue if your notary works for your property management company, or is this commonplace? A notary just can't sign their own for themselves, so a notary can't sign as signatory and then notarize their their signature as well. So I don't necessarily see an issue as long as they are acting in accordance with their duties and responsibilities in this state or municipality where they're licensed. Would you agree, Gary?
Yeah, yeah. I think the only time you'd have to be concerned about the identity of the notary in particular is in a rare instance where, for some reason, that person had an interest in the document that everybody was signing. But typically, management company employees are not going to have that issue.
Are online notaries legal to use? Your Massachusetts does not permit people to online notary signatures. You have to sign in person.
Next one, I'm the president of the board as well as a 61% shareholder So how do I express my concerns without recusing myself from all matters? So excellent question, because that's a scenario where one person has a lot of involvement in the association. The 61%, you're going to get to vote that, as the unit owner that owns that percentage. And so you're always allowed to vote your unit vote. When it comes to recusing yourself, that would just be to the board discussions and the board decisions if you have a personal stake in that decision. Now, I get that if you own 61% of an association, arguably, you have an interest in everything at that community because most of it is yours. But when it comes to recusing yourself, it's really a specific interest. In other words, if your interest is the same as others in the community, or if your interest lines up with the general interest of the community, that's not a recusal situation. A recusal situation is when it's very particular to you. So in other words, if you were petitioning the board to replace the roof on your own unit because your roof is leaking and it's leaked before and you just want a brand new roof, you want to be doing that as the owner and let the rest of the board vote on that.
Or if it was a 5-unit association and you own the 3 commercial units and the other 2 are residential, and you want to take action that's only favorable to the commercial units, that would be something, again, you have to act in the best interest of the association, not any one individual owner or resident. So you have to think of you have to act as you have even a more heightened sense of duty, fiduciary duty as in your role as a majority shareholder and on the board.
Next one says that the New Hampshire Condo Act was revised in 2024. What is the deadline to bring condo docs up to the 2024 revisions? Also, does the act supersede the condo bylaws? Couple things there. Many of you are probably familiar with CAI. That is the Community Associations Institute. No business affiliation here, but they're a great organization. They're a nationwide nonprofit, and their only goal in life is to make association living better. They have a legislative action committee in every state, which is comprised of volunteers who are willing to keep tabs on the changing law. For New Hampshire, I chair that committee, and all of that is background to the answer I'm about to give. That's the explanation for why I know this answer. There isn't a deadline for associations to bring their docs in line with the law. The legislators originally were going to impose one, and we made them understand the dilemma of being on a board. When you're amending documents, you need a meeting to happen. You need to get your attorney involved. You have to spend that money, which means you have to have that money. Some associations have a real hard time getting quorums at meetings. And last but not least, even if the amendment makes perfect sense because it's to comply with the statute, you can't force people to vote for it. And so, we impressed upon the legislators, those of us on the Legislative Action Committee, we impressed upon them that, board members, as hard as they may try, they don't have 100% control over this situation. So please don't do that to them, because then if their documents aren't amended and they're not amended in the time frame you give them, now the association's in violation, ongoing violation of the statute. And what does that mean? And what good does that do anybody? And so that provision was eliminated. That's the good news. The bad news is, in answer to the second half of the question, the act does supersede the association's bylaws. And in fact, in New Hampshire, the Condominium Act is 356B, and it's section 6-a, and that is the section that explicitly states that the act is going to control if there's a conflict in the language between the act and your association's documents. And so, while you don't have a deadline to amend your documents, you should in New Hampshire always be aware of what the statute says. And if your docs are any different, because even if your docs are different, you are going to need to comply with the statute.
That's a good recommendation anyway, don't you think, to periodically review the documents, especially in the older associations where the facts and circumstances that at issue when the condominium was created, decades ago may not be relevant any longer. And so they should be updated periodically and reviewed periodically, especially insurance provisions to reflect the current needs of the community.
Absolutely. My favorite example of that is a sort of funny story, as long as you're not the association, this particular association. Their docs were so old that their fines were $5 for violation. Now, it did provide that you could charge a fine for every day that a violation continues. However, we were dealing with a place in Boston at the time. And the issue that I was working on was someone who was parking illegally. And I got a response to the notice, which is nice, but it was them calling me to say they wanted to discuss the situation and make sure they understood. And they said, let me get this straight. You can fine me $5 for every single day that I park there? Yes. And that's going to be about $150 a month. And I said, yes. And they said, fantastic. That is the best deal in all of Boston. And so the point is that, especially dollar amounts and things of that nature, if they're in a set of condo docs long enough, they're going to get so outdated that they're going to be meaningless. And you really need to look at these things, as Jenny was suggesting, on an ongoing basis from time to time so that you can do your updates and stay relevant in every way, not just with the law, but with common practices like associations now all want to have electronic meetings. It started during COVID. People realized they like it. Now they keep wanting to do that. Most associations documents were written back when Zoom meant moving quickly. So, you're going to have to change your documents from time to time to keep pace with society. And then also, with financial matters for things like fines.
But that brings us to that question, another question. If the meetings are held remotely, should there be a hard copy, I'm assuming document showing what was voted on, and should all board members sign it? And I would say yes, you still, just because the meeting's held remotely, if you're because of your jurisdiction or your governing documents require meeting minutes to be kept and then you still need to follow those those rules, and even if the meeting is held remotely or virtually.
This next one says for New Hampshire resale certificate, which is the equivalent of the 6D, as it's called in Massachusetts. Does that document need to be signed by all members, or can it just be signed by the president or the treasurer? And at this association, they've noted that their treasurer is not a voting member of their board. It's a specific separate appointment. So this is covered by statute in New Hampshire, and I believe it is like the liens that you want it to be an officer of the board. And so the question really turns on whether or not the person involved is an officer of the board. So you could be an officer, such as a treasurer, without voting, but the treasurer status would make you an officer of the board. But there is a statutory provision for that. It is, I think, right about section 58 or so. Jenny, if you want to take the next one, I'll take a peek.
All right. So if this is regarding the election of board members, if there's no provision in the docs and there's a vote for a board member seat, and the vote ends in a tie, what's the best action to take? As a general rule, I've always recommended that the board member or trustee continues to serve until their successor is elected or appointed in accordance with the governing documents. It might require calling another special meeting if there wasn't a quorum, or if there's a vacancy on the board, then because of a term expires or someone resigns, then or someone resigns, I should say, or they just no longer are eligible to serve on the board, uh, they can be appointed in accordance with the governing documents following, again, every association's governing documents are a little bit different, so I don't want to make a blanket rule, but I would follow it. But as a general rule, unless there's a vacancy, the current trustee or board member should continue to serve until their successors elected or appointed. And I say that only to continue to operate the association and to ensure that the business of the association continues uninterrupted, is rather than leave the a board member, or one board member or two board members without sufficient authority to act.
And so just taking a quick step back on the prior question about the resale certificate, it is section 58 of the statute. And it says the principal officer of the unit owners association, which would be the president, or such other officer or officers as the condominium instrument may specify. And so what does that mean? It means that when it comes to the resale certificate, it's actually going to be the president unless your association's documents say it can be someone else, and that someone else does need to be an officer of the board. Again, if the treasurer is an officer, then they'll meet that definition if that's what your docs say. I wouldn't worry about the fact that the treasurer doesn't get to vote on issues at your association. If your docs allow other officers and the treasurer is one, then they can. But the default under section 58 would be the president of the association, that being the principal officer of the association.
What documents are needed to legally represent an owner in relationships with the condo? I'm not sure what that one means. The board shouldn't be entering into agreements with individual unit owners unless it's a repayment agreement, or an agreement, in the context of litigation. And if that's the case, it should really be entered into after consulting an attorney. Unfortunately, it's difficult to respond to that question without knowing the circumstances or the specifics of the context of the agreement or how it would arise.
I wonder if they mean that the unit owner wants legal representation, relative to some dispute or situation with the condominium, and they want legal representation of their own. If that is the question, I would say that that is not going to be the same person. In other words, the association's attorney, because they represent the association, they have confidential information of the association, they owe duties to the association. The association's attorney is not going to be able to represent individual unit owners.
Let's see. If a board has agreed on a contract, one board member signed the contract, is an email thread sufficient to show majority of the board voted in favor? Unlikely. I mean, it helps if often the documents will specify that if you vote outside of a meeting, how to ratify that vote. If it, many times we'll say something to the effect that if the unit owners or the board may act without a meeting by a document signed by all the trustees or all the members of the board. So if that's what the documents state, then that's what you should do. An email is helpful, but it's not going to supersede the documents or the statute. Let's see. Do meeting minutes need to be signed in order to be valid? Not in Massachusetts. Let's see. Legal notice by email, unless your documents allow for that.
So that one's a little different in New Hampshire, because in New Hampshire they put that in the statute. And in New Hampshire, your documents don't necessarily have to provide for it, but the trigger under the New Hampshire Act is that the unit owner must have designated an email address for you. And so as long as the owner is saying, you can use my email address to communicate with me for association business, then yes, if it's New Hampshire.
I would still use regular mail or delivering a copy to the unit as an added precaution, just because of, the potential issues if you type even a letter wrong or the person's or it just that's due to spam filters and the like. I just wouldn't want to challenge about notice because of a technicality, you know, both a actual technicality and legal technicality. Um, so let's see. If board requires no less than three and no more than five members, and no one will volunteer to make the board a minimum of three, what can be done?
Well, now my joke doesn't seem so bad from earlier. I mentioned that I have this theory that all board members are on board because they've been forced to be there. That is a common thread. And yeah, unfortunately, that's kind of what you're left with in those situations where no one will step forward voluntarily. The board is kind of left with identifying, I'll call them targets, and then pursuing them and convincing someone to do it. There is, at the end of the day, a very last resort measure. And sometimes you can communicate this to the owners and again, sort of motivate slash leverage someone into coming forward. But if an association under their own documents doesn't have a sufficient board to conduct business, then they're just sort of dead in the water, so to speak. You know, nothing's happening, nothing can happen. Dangerous place to be. Um, Under those circumstances, owners could go to a court and ask for a court-appointed receiver to be put in place.
That's a remedy of last resort. It's if their property is in danger of suffering waste and loss. Um, you're basically asking the court to appoint some outside one person to come in and act as have the full authority of the entire board to take action, and their fees, they don't act for free. Um, they are going to recover their fees by charging the association. And if they think that work needs to be done, they're going to do it. And again, you're taking any sort of uh, power or control over your association and giving it to into putting it into the hands of an unknown entity.
Yeah, agreed. Very last resort. Where it's helpful is often just in the mention of it. In other
Mhm.
words, I've been to at least over the past 20 plus years, I've been to at least three meetings where the board desperately needed someone to get on the board. No one was stepping forward. And on at least three occasions that the board members have said, well, if no one will fill this slot, here's what we're going to be left with. And they describe to the community the option of the court appointed receiver and how bad that can be. And after hearing all of that three times, there's been someone who says, all right, fine, I'll do it. I'll save us from the court appointed receiver. So, you know, sometimes it's an option that you don't want to take, but it's an option that you mention it to the community to provide people motivation to come forward so that you don't end up in that situation.
Reasonable regulations that a board can enact versus what kind of regulations require amending the trust. As a general rule, the board can enact rules and regulations governing the use of the common elements, but that's not always the case. I have had some associations do have provisions in their documents requiring unit owner consent even for the adoption and amendment of regulations. So you have to look at your documents. Assuming that's the authority, you can't regulate the use of a unit through a rule and regulation. That's going to require an amendment to the governing documents, the master deed and or the trust, depending on specifically what you're seeking to amend. If the pet one is a great example that comes up a lot. You can regulate pets on the common elements. You can say that pets, you have to maintain control, you have to pick up after your pet on the common elements and maintain keep them on a leash, but you can't say use a rule to state that you can only have one pet in your unit, or you can only have a specific type of pet in your unit.
Yeah, I would agree. General rule is it kind of stops at the door of the unit. And once you're talking about impacting what goes on inside the unit, you're talking about amending the docs. Um, I have seen, as Jenny mentioned, you do have to look at the language about the board's ability to make rules because I've seen it, as she mentioned, where the community has involvement in passing the rule. I've also seen only once, but I have seen a variation of that where the board can make rules, but I guess if the community doesn't like the rule enough, the community can repeal
Yeah.
by a certain vote rules that the board has made. So you do have to be mindful of what that language is and what role, if any, the community has in the rules either way.
And I guess the last one is, why isn't there a state or federal code of ethics and standards for both board members and property managers, aka agents in particular, to manage conflict of interest? Well, there's fidelity bonds that are often recommended, and you're required for any property manager owed to the association. Uh, and that you have to just look at your governing documents. So that's an added measure of protection if your documents call for it. The as a rule, the association and the board members and the property manager owe a fiduciary duty to act in the best interests of the association. And the governing documents, they often have what's called an indemnification provision, meaning that the board members are not going to be personally liable or exposed to, liability if they act within the scope of their duties and responsibilities in good faith. So if they act outside of their duties, if they act in bad faith and they're to advance their own personal self-interest, they may face personal liability and their assets subject to exposure in the event that the association or the person that is aggrieved were to prevail after a trial.
And this can be a careful what you wish for sort of thing because a little bit of a war story from New Hampshire, and this gets back to the Legislative Action Committee again. They were looking at this issue. Do we need to box people in a little bit better and make sure that they do the job and do it right? Well, unfortunately, what they came up with at one point was a bill that would have exposed board members to criminal liability relative to their mistakes as board members. And there was a public hearing on that bill, and I'll never forget, there were hundreds of people crammed into the State House. The room was beyond capacity. The line of people waiting to speak went out of the chambers and outside into the hall. And most of the speakers were board members who were basically saying to the legislators, pass this, and here's my resignation. It will be turned in immediately. I won't be on the board. Good luck finding anybody to be on the board. And it didn't pass, which is great because we certainly don't want board members to be subject to criminal liability. But this can sometimes be the trouble when we get into regulation. Sometimes we end up with more than what we really want. With property managers, I know it has in New Hampshire. I think it might also be the case that it's been dabbled with in Massachusetts a bit as well. The idea of licensing property managers, making it a profession where you'd have to meet certain criteria and have your license. And then there would be a state authority, sort of governing that to a certain extent. But thus far, in neither state has it taken hold enough to actually become a reality.
But CAI, you mentioned earlier, has a lot of great resources and educational training available for both board members and property managers to help educate. A lot of the, mistakes come from just not knowing what to do in certain instances. acting as a board member, acting as a property manager, that is an enormous undertaking, and it's not for the faint of heart. So I don't think we should penalize them by imposing sanctions for honest mistakes of judgment, or just because they don't necessarily have all the facts. Uh, Last question, I think, is, let's see, or no, if a conduct state a board member doesn't have to be an owner, what's the best way to change this to require all board members be owners? An amendment to the governing documents. With rental restriction in case of exemption is a limit to 1 year acceptable. I'm not sure what, I don't necessarily know if I understand the question. Rental restrictions, if they're in the documents, then you're, that is what you're required to be, rental restriction in case of an exemption. So if you're trying to adopt a rental restriction and, if I'm going to, I guess just guessing at what is intended by this question, but I guess is it 1 year rental restriction reasonable to require to, if the goal is to prevent short-term rentals or transient use, then that would be a good way. Even 6 months may be, sufficient to limit or to prevent the use of a property for short-term rent or transient rentals through Airbnb, VRBO, or the like. And so, but again, if the documents don't currently provide for such a restriction, that can really only be accomplished through an amendment to the documents.
And that's a pretty common amendment, and it's getting more and more common to see a year. In the past, a month was common, 3 months was common. At some point, 6 months was common, and now I sort of see it, being a year that people are interested in. I think because, short-term rentals have gotten a bad rap where, people are in and out, and there's too much of that and nobody likes it. Um, Another spin on this question might be, I admit I'm not positive that I understand it exactly, but another spin on this question might be a variation that some associations do where you can't rent your unit until you've lived there for a certain amount of time. I guess the idea being that, they want everyone to actually experience the community, know their neighbors, hopefully care about the community, before they become a landlord and start having a tenant there while they live elsewhere. Those provisions, if they're in your documents, are enforceable. If they're not in there and the community wants them in there, if you pass it as an amendment, then that becomes enforceable as well.
I think the intention, you'd have to discuss what your objectives are with the association's attorney, and they could help guide you in terms of how to best approach uh, what provisions or they would recommend to accomplish what your goals and objectives, or what you're trying to prevent against.
Yep, agreed.
So thank you all for sticking with us. I know we've gone well over our 1 hour limit. We're overachievers here. So uh, if there's no other questions, or if you have any other questions that we didn't get to, Gary and our contact information is up on the screen. Please reach out to us, and if we can't personally answer, we will put you in touch with someone else in our office who can. But thank you so much again. We hope you found this informative and enjoyable, at least somewhat, even if it's a little.
Thanks, everybody, for taking the time today, and we hope to see you again at one of these in the future.